A financial remedy order. What is it and why might you need one? Divorce can be a challenging process, especially when it comes to agreeing on how your assets and your finances will be divided. For those instances where couples simply cannot reach an agreement, well, that's where a financial remedy order comes into play. A financial remedy order is a court order that outlines how divorcing couples must divide their assets and finances as part of the divorce settlement. A financial remedy order covers a wide range of assets and finances, including property, savings, investments, and pensions. It can also be used to make arrangements for spousal maintenance, which entails one party making regular payments to the other to support their essential living costs for a fixed period. The judge issuing the financial remedy order doesn't necessarily have to split the assets and finances equally. The primary consideration is to ensure that the order is fair to both individuals involved. There are different types of orders, such as a financial consent order and a financial remedy order. A consent order is a court order used to make an out-of-court arrangement legally binding. This applies when divorcing couples agree on how to divide their finances and assets, but want to ensure that the agreement holds legal weight. Without a consent order, one party could potentially make a claim for money in the future, even after the divorce has been finalised. On the other hand, a financial remedy order is sought when the couple cannot agree and have exhausted other resolution options. It's a means to resolve their disagreement and make the decision legally binding. Before resorting to a financial remedy order, you will be required to consider mediation services. Mediation involves a third person who assists the divorcing couple in finding resolution. They don't offer legal advice or take sides, but can provide proactive suggestions for consideration. Mediation is compulsory except in cases where domestic violence has occurred within the relationship. If mediation doesn't lead to a resolution, then another option may be a collaborative law session, where solicitors from both sides meet to discuss the situation and strive to find a resolution that works for their clients. When it comes to applying for a financial remedy order, you must fill in a form and submit it to the court handling your case. Once your application is submitted, there are 3 stages to obtaining a financial remedy order. Firstly, you'll have an initial short appointment with a judge to discuss the matter. Secondly, a financial dispute resolution hearing will take place, aimed at resolving the matter early without the need for a judge's intervention, and multiple such hearings may occur. And thirdly, there will be a final hearing where a judge makes a lasting decision. Once the financial remedy order is issued by the court, the agreement becomes legally binding. Both parties must adhere to the terms of the agreement, and no future claims for money or assets can be made. Even with the most amicable of divorces, it can still be worthwhile to consult with a solicitor for expert advice on how to proceed. These days, there's many online solicitors that can work out cheaper and easier than meeting in person. JustAnswer, for example, only costs £5 for a trial, which could be far less than an in-person traditional meeting. One of my colleagues used their service and saved over £270 on an outstanding parking ticket. I've linked that offer in the description. If you use that, you'll also be supporting Money Nerd, so thank you.